Good morning, this is the Kelso Report for Friday, January 27th, and I'm your host, Clark Kelso. We begin today with federal sentencing. Now, as a general matter, sentencing in federal courts is so heavily influenced by the sentencing guidelines that it is rare to see a sentence reversed for something other than misapplication of the guidelines or some other calculation error. But in United States v. McGowan, the Ninth Circuit was presented with a 51-month sentence imposed upon a former state prison guard who had been convicted of assaulting two inmates, where the length of sentence was largely determined by allegations of drug use leveled at the defendant by a prison inmate. Now, the appellate panel had concluded that the inmate allegations, which were submitted in a written report about prior FBI interviews with the inmate, was submitted as part of the sentencing hearing, that was insufficiently reliable to serve as a basis for sentencing. The panel remanded to a new district judge for re-sentencing. The court also held on an unrelated procedural issue that a judge granting a motion for acquittal may conditionally rule on a motion for a new trial only if the defendant has made such a motion, which the defendant did not make below. The defense counsel's failure to make that motion was also asserted as a basis for reversal, but the Ninth Circuit held that this ineffective assistance of counsel claim was more appropriate for a habeas petition. It's pretty clear that post-trial motions here and the sentencing was all messed up by both the defense counsel and the trial court. I think the Ninth Circuit's hoping that on remand with a new judge, this thing will be done a little bit better. Our next case in the Ninth Circuit involves immigration. Now, in immigration proceedings, the credibility of the alien story is of paramount importance, and an adverse credibility finding is almost sure to sink the alien's petition for relief. Well, that's what happened to the petitioner in Oshodi v. Holder, where the petitioner was seeking withholding of removal and relief under the Convention Against Torture to avoid being returned to Nigeria based on his fear of persecution and torture due to his religion and political opinions. The immigration judge made an adverse credibility finding based on the petitioner's use of various false names, his inconsistent statements regarding ownership of certain Nigerian property, his inconsistency regarding whether his father was living or deceased, his conflicting testimony regarding whether his father or grandfather was involved in politics, his failure to list all 10 of his siblings on his application, the fact that his father traveled to and from Nigeria, apparently without persecution, and his failure to provide corroborating evidence to establish a reasonable fear of persecution. It's quite a list. So the Ninth Circuit concluded that the adverse credibility determination was well supported by this evidence, and the decision by the immigration judge to deny relief was affirmed. Next, we move to the California Court of Appeals, first to the area of criminal law. In California, theft of property from the person is considered grand theft, no matter how much the property is worth. Now, to be considered theft from the person, the property must have been in the clothing of, on the body of, or in a container held or carried by a person. In People v. Getter, the Third District held that there was insufficient evidence to support a conviction for grand theft when the evidence, which included a videotape of the crime, showed that the victim had left around $100 in bills at an ATM machine after being confronted by the defendant. And then the defendant took the bills after the victim had fled. On these facts, the property was not on the person of the victim or within his reach or control. So the defendant could be convicted only of petty theft, not grand theft. Next, we have an appellate jurisdiction problem. According to the probate code, an order, quote, compelling the trustee to submit an account or report acts as trustee, close quote, are not appealable on accounting or a reporting access trustee. Those are not appealable orders. In Christie v. Kimball, the Superior Court had consolidated 3 separate cases involving a single trust into one case and ordered an accounting simply to clarify and determine what assets were in the trust. The Second District concluded that a probate court's general power to supervise administration of trusts permits it to order a trustee's accounting on its own motion, and that such an order is not appealable. Now, there is an exception to the non-appealability doctrine here if the order directing the accounting implicitly adjudicates other issues. But in this case, the accounting really was for no other purpose than to assist the court in identifying trust assets. So the exception did not apply, and the order was not appealable. The next case involves the area of family law and reunification. In Tracy J. v. San Diego County Health and Human Services Agency, the 4th District reversed the juvenile court's order terminating family reunification services and setting a hearing under Welfare and Institutions Code Section 366.26. The parents in this case were developmentally disabled, and even though there was no evidence showing that the parents' behavior has jeopardized or would jeopardize the child's safety, the agency had limited the parents' visitation because of concerns about the parents' mental health status. The 4th District concluded that the parents did not receive reasonable family reunification services from the agency. There were positive reports from professionals about the parents' devotion to the child and to his safety, but the agency still had limited visitation notwithstanding those reports. The court directed the juvenile court to continue the 18-month review hearing for 6 more months, to order the agency to expand the parents' visitation with the child, including unsupervised visitation, and to request a parenting assessment of the mother. In other words, we're going to give the parents here another chance, let the agency do a better job of reunification services, and then we'll see what happens 6 to 12 months from now. That's it for today's Kelso Report. Have a great day in the law.